Hello everybody, welcome back to my channel Simplified Basic Concepts. Today in this video I'll be discussing about the Payment of Gratuity Act 1972. See, earlier there were many labor legislations which were prevalent in our country, but recently major labor codes have been made. That is, there are new labor codes under which all the similar legislations have been clubbed and put together to remove all the difficulties which were faced earlier due to these number of legislations. So the four new labor codes are the Code on Wages 2019, Code on Social Security 2020, the Industrial Relations Code 2020, the Occupational Safety, Health and Working Conditions Code 2020. Now, under Social Security Code 2020, there are 9 labor legislations which have been clubbed together and has been put under it. Now, all these 9 labor legislations are related to social security of the employees, right? That's why they have been put under this Social Security Code. The 9 labor legislations are Employees Compensation Act 1923, Employees State Insurance Act 1948, Employees Provident Fund and Miscellaneous Provision Act 1952, the Employment Exchange Compulsory Notification of Vacancies Act 1959, the Maternity Benefit Act 1961, Payment of Gratuity Act 1972, the Cine Workers Welfare Fund Act 1981, the Building and Other Construction Workers Welfare Cess Act 1996, and the Unorganized Workers Social Security Act 2008. But here in this video we will not be discussing about the Social Security Code. I'll be talking particularly about the Payment of Gratuity Act 1972. Right. Before going into details about the Payment of Gratuity Act 1972, let's first understand the meaning of the word gratuity. Gratuity basically is derived from the word gratitude, which means thankfulness, right? And here in Payment of Gratuity Act, gratuity is the sum of money that the employers pay to their employees as a sign of or as a token of thankfulness for the services which the employees have performed or rendered over years, right? Now, as the definition of gratuity says that it is a token of thankfulness, it doesn't mean that this is not compulsory and it depends on the will of the employer to pay or not to pay gratitude to the employees. No. Gratuity here, as per the Payment of Gratuity Act, if certain conditions are being fulfilled, then it becomes compulsory on part of the employer to pay gratuity to its employees, right? Now, any company, whether it is a public company or a private company, which has 10 or more employees, then that organization will have to pay gratuity to its employees. See, by this 10 or more employees, it's meant here that if on any single day also in previous 12 months, 10 or more employees were employed in the organization, and after that, if the workforce has been reduced to less than 10, then also the company is liable to pay gratuity to its employees. Right. So companies with a workforce of 10 or more than 10 employees on a single day in previous 12 months are subject to pay gratuity to its employees. And even if the employees of the company are reduced to below 10, still it will be liable to pay gratuity as per the Gratuity Act. Right. The second condition is gratuity is paid to employees who have completed 5 or more years of service in the organization, right? So any organization where there is 10 or more employees working and the employees who have completed 5 years of service in the organization will get gratuity. As per the Payment of Gratuity Act, in case of employee's death or disability, there is no minimum eligibility period for getting gratuity, right? Just now I mentioned that any employee who have completed 5 years of service, he will only be getting gratuity at the end of his service, that is at the time of retirement. But as per Gratuity Act, in case of death or disability, there is no minimum eligibility period for getting gratuity. The gratuity amount here is payable up to the date of death, irrespective of whether the employee has completed 5 years of service or not. So if an employee working in an organization for 1 year and after 1 year of his service he expires, then he is eligible to get the gratuity. Right? Now, gratuity in case of death of an employee is paid to his nominee, and if no nominations have been made by the employee, then the gratuity will be paid to the legal heir. Legal heir means in case no nominations have been paid, then those individuals who has the right and entitlement to succeed to the wealth and property of the deceased individual, to them the gratuity will be paid. And where any such nominees or heir is a minor, then the share of such minor shall be deposited by the controlling authority, such that when the minors attain majority, they'll be getting that amount, right? Now, when an employee passes away, gratuity paid to his wife or legal heir will be exempted from tax. See, gratuity is a part of cost to company, that is CTC of an employee. That is why income tax is applicable on payment of gratuity, as it is viewed as a part of salary. But gratuity, like provident fund, is not deducted from the salary of an employee, and neither the employee has to contribute for it. Now, scope of coverage of this act. Every factory as defined in Factories Act, mines, oil field, plantation, ports and railways comes under the scope of Payment of Gratuity Act 1972. Every shop or establishment to which Shop and Establishment Act of a state applies, and in which 10 or more persons are employed, where the work is done with the help of power, and 20 or more peoples are working where the work is done without the help of power at any time during the year, then those organizations too will come under the Payment of Gratuity Act, right? That means these organizations too will have to pay gratuity to its employees. Payment of gratuity shall be payable to the employee on termination of his employment due to retirement or superannuation after he has rendered continuous service or deemed continuous service for not less than 5 years, right? Now, the maximum amount of gratuity that an employee can receive from his employer is up to 20 lakhs. He cannot get more than 20 lakhs of gratuity, even if the gratuity amount is exceeding 20 lakh, the upper limit of receiving gratuity is up to 20 lakhs. So for computation of period of service for gratuity calculation, the maximum number of years that can be taken is 33 years, even if an employee worked beyond that tenure in an organization. So if an employee has worked for 35 years continuously in an organization, then also at the time of calculating his gratuity, the number of years which will be taken into consideration will be taken as 33 years, as beyond 33 years the year of employment is not taken into consideration while calculating gratuity. Let's first understand these two terms, continuous service and deemed continuous service, which is important for payment of gratuity. Let's first understand continuous service. See, as per this act, an employee should have worked for 5 continuous years in an organization, then only he is eligible to get gratuity, right? That is, after 5 years of service, he'll become eligible to get gratuity, and he will get gratuity at the time of his retirement or superannuation. Now, continuous service means uninterrupted service, but here there are certain permissible interruptions which when an employee takes, that is also considered as a part of his continuous service. So what are those permissible interruptions? That is, when an employee is not going to his workplace or absent from his workplace due to sickness, accident, he has taken some leave, or absence from duty without leave in accordance with the standing order, or maternity leave for 26 weeks. So these are the leaves which are permissible interruptions. Then comes layoff, strike, lockout, cessation of work, not due to fault of the employee. So these are those permissible interruptions which, when taken during the tenure of an employee, will be considered as continuous service performed by him, right? Deemed continuous service means, let's first understand the meaning of word deemed. Deemed means considered in a special way. So in a special way, how can we consider continuous service? Now, there are two conditions. Either an employee performs continuous service with permissible interruptions, or an employee has taken interruptions. So when an employee is not performing continuous service, he shall be deemed, that is considered in a special way, to be working continuously if the working day conditions are satisfied. Let's again understand this, that either a person is performing his duty in a continuous basis with taking these permissible interruptions during his 5 years of tenure in the organization, right? Or if apart from these interruptions also he has taken more leaves which are not mentioned here, then in that case also he will be considered to be in continuous service if he performs or satisfies these numbers of working day conditions. Clear? So in seasonal establishment, if an employee has worked for not less than 75% of the number of days on which the establishment was in operation, right? See, we know that seasonal establishment means those organizations which work on seasonal basis. So let's understand this, that if a seasonal establishment has worked for 100 days, so an employee who has worked for 75% of 100 days, that is for 75 days in the organization, he will be said to be in deemed continuous service, right? Maybe he has taken certain non-permissible interruptions or non-permissible leaves from the organization. Then also, if he is satisfying this 75% of working day condition, he will be considered to be in deemed continuous service and he is eligible to get gratuity at the time of retirement or superannuation, right? And apart from seasonal establishment, the number of days an employee works in an year or in 6 months time satisfies the working day condition will be considered to be in deemed continuous service, right? Now, for other than seasonal establishment, let's first understand deemed continuous service in a detailed way. For a period of 1 year, if a worker has worked for not less than 190 days, in a case of employee employed below the ground or in a mine or in an establishment which works for not less than 6 days a week, right? And in other cases, he should have gone 240 days to the workplace. Then in these two cases, he will be considered to be in deemed continuous service. And now for this period of 6 months, if the employee has worked for not less than 95 days, in case of employees who are employed below the ground in a mines or in an establishment which works for less than 6 days in a week. And in other cases 120 days, that is in other cases he have gone to the workplace for 120 days, then he will be considered to be in deemed continuous service, which makes him eligible to get the gratuity, right? See, it's clearly shown here that deemed continuous service for seasonal establishment and for other establishments. For seasonal establishment, an employee needs to go for not less than 75% of the working days, which I explained earlier is if a seasonal establishment works for 100 days, then the employee needs to go for not less than 75 days. Then he'll be considered to be deemed continuous service. Now we can see here for other establishment for 1 year tenure and for 6 months. So for 1 year we can see that where the working days is less than 6 or where the employee needs to go underground in the mines, then he need to go there for 190 days in 1 year time. And for other employees it's 240 days. So if an employee in this condition goes for 190 days in 1 year time, and in other conditions if an employee goes to organization for 240 days out of 365 days, then also he will be considered to be deemed continuous service. And for 6 months time, we can see that in the first case where the working days are less than 6 days and the employee works under the ground, then he needs to go to the workplace for 95 days. Out of 6 months, he needs to go to the workplace for 95 days, and in other cases the employee needs to go to the workplace for 120 days. Then he will be considered to be in deemed continuous service. So when these two conditions are being fulfilled, then an employee is eligible to get the gratuity, right? So let's see this once again, that gratuity is payable to an employee on termination of his employment due to retirement or superannuation after he has rendered continuous service or deemed continuous service for not less than 5 years. We need to see that what are the conditions under which gratuity is paid before retirement. When an employee switches his job, that is changes his job after completing 5 years of service, at the time of leaving the service, he will be getting his full and final. So at that time also, he can get the gratuity from the organization. Second condition is if an employee dies while in service, gratuity amount is to be paid to the nominee or legal heir. Now this we discussed earlier that in the case of death or disablement of an employee, there is no time limit or time boundation for payment of gratuity. In these cases, he can get the gratuity before retirement, right? Second, as I said, disablement due to accident or a disease. And the fourth condition is on termination of the employment of an employee, he'll be getting gratuity. And finally, if an employee opts for VRS, VRS is voluntary retirement scheme. So before retirement, if an employee opts for VRS, voluntary retirement scheme, then also he'll be getting his gratuity. Clear? When gratuity can be forfeited, that is the conditions under which an employee cannot get gratuity from his employer. So there are certain conditions of misuse or misappropriation of asset by the employee, or in case of molestation, assault, theft or fraud done by the employee. If an employee is found to be involved in these situations, then an employer can forfeit his gratuity. Now the gratuity payment. A person who is eligible for gratuity or the authorized person on his behalf can send a written application to the employer for payment of gratuity. See, a person who is eligible means the person who is working, or the authorized person can here be, in case of death or disablement of an employee, the nominee or the legal heir, right? Now, when the gratuity becomes payable, the employer himself shall determine the amount of gratuity and give notice in writing to the person, that is to the employee, to whom the gratuity is payable, and also to the competent authority, specifying the amount of gratuity which is found, right, or which is determined. Then the employer shall pay gratuity to the concerned person, that is to the eligible employee or the authorized person, within 30 days from the date it becomes payable. And if the gratuity is not paid by the employer within this specified period, then the employer shall pay simple interest at the rate notified by the central government from the date on which the gratuity becomes payable to the date on which it is paid. Right. So in case if the gratuity is to be paid within 30 days, and if an employee is not getting his gratuity even after 45 days, then in that case the employer will have to pay for this extra day, that is 45 minus 30, 15 days. For 15 days he will have to pay simple interest to the concerned person along with the gratuity. Clear? Compulsory insurance. Gratuity is the right of every employee, even if the employer goes bankrupt, and no court can deny the gratuity payment to the employee if he or she is eligible for it. That is why, to make sure that every employee gets gratuity, in worst condition too, even if the employer gets bankrupt or goes bankrupt, a compulsory insurance is to be maintained by every organization where there are 500 or more employees. Right. Now, other than the establishment which are under the control of central government and state government, that is the employer or establishment which are under the control of central government and state government are free to opt out from this compulsory insurance, right? Now this insurance shall be obtained by the employer or organization from any insurance company that is regulated by the Authority of Insurance Regulatory and Development Authority Act 1999. The appropriate government at any time may exempt the employer who had already established an approved gratuity fund in respect of the employees, right? So under compulsory insurance, we see that as gratuity is right of every employee, so to prevent any type of mishappenings because of which the employee may not get his gratuity, the government has made it sure under Payment of Gratuity Act that all the organizations where 500 or more employees are working, they should obtain an insurance for liability of payment of the gratuity. Secondly, if the government finds out, that is the appropriate government, if any time finds out that the employer or an organization already have some sort of approved gratuity fund, then they can exempt those organizations from obtaining insurance, right? Then competent authority. The appropriate government may by notification appoint any person having such qualification and experience as described by the government to be a competent authority for implementation of the provisions of this chapter. Then inspectors, the appropriate government by notification appoint as many inspectors as it deems fit for the purpose of this act. Every inspector shall be deemed to be a public servant, right? Now, power of the inspector is the inspector can demand that an employer provide whatever information that he may deem necessary. He can enter and inspect the premises that comes under the act and examine all the records or necessary documents related to gratuity, right? Now he also has the right to inspect the employees who are present on the premises. Then amount of gratuity payment. See, for every completed years of service or part thereof in excess of 6 months, the employer shall pay gratuity to its employees at the rate of 15 days wages based on the rate of wages last drawn by the employee. Every 6 months count as a year only after 5 years of service. That is, if there is 7.6 years of work experience, then for an employee it will be rounded to 8 years, while 7.4 years would round down to 7 years of gratuity payment. Only when an employee has completed 5 years of continuous service in the organization. Now for piece rated employees, how will the gratuity be calculated? Here the daily wages for them shall be computed on the basis of average of the total wages that is received by the employee for the period of 3 months. That is 3 months average will be taken as the daily wage for an employee, right? Which will be immediately preceding the termination of an employee. So when an employment of an employee is terminated, 3 months preceding that tenure, the average of those 3 months salary will be taken, and from that daily wage will be computed for the piece rated employee. Okay, and for this purpose the wages paid for any overtime work shall not be taken into account, right? So here overtime work will not be taken into consideration, that is wages paid for overtime work. Now in case of an establishment which is working on seasonal basis, the employee here will be those who work throughout the year. 15/26 computation rule will be applied, and those who work only during the seasons, then for those employees 7-day wages will be taken into consideration, right? See, here we can see that formula of gratuity calculation is monthly salary, number of years, and into 15/26. Right, monthly salary means basic plus dearness allowance, right? Number of years means total number of years in employment, that is number of years you have completed in the organization, right? And 15/26 here means 15 days of salary for every 26 days of work. Why 26 days? Because the 4 Sundays are being excluded from the month. Okay. Now here what I was explaining is, for employee who are working in seasonal establishment, here instead of 15/26, for them the salary will be 7/26. Clear? And For piece rated employee, this monthly salary, how this will be calculated? The time when their service is being terminated, prior to that 3 months salaries average will be taken as the monthly salary of the employee. Clear? For piece rated system, I'm clear, the average of 3 months salary will be taken. And for seasonal establishments where the employee has worked throughout the season, for them this same formula will be used for gratuity calculation. And who has worked for few season, for them 7/26 will be taken into consideration while taking gratuity. Okay. Now here there are all the formulas. For seasonal establishment, the formula for calculating gratuity will be last season's salary divided by last season days, that is number of days the worker has worked, into 7 into number of seasons worked. Clear? For monthly rated employees, it will be last drawn salary into number of years of service into 15/26, the formula which we saw in the previous page. For daily rated employees or piece rated employees, it will be last 3 months average wage, number of years of service into 15/26. Clear? Now let's understand gratuity calculation with the help of an example. Now let's assume that a person is getting a salary, monthly salary of 1 lakh rupees. This 1 lakh means his basic and DA. Okay. And an employee has worked for 12 years in the organization. His gratuity will be 15/26 into 1 lakh into 12, which is 6,92,307. Now here in place of 12 years, if a person has worked for 7.8 years, that is 7 years and 8 months, then at the time of gratuity calculation we will be taking 15/26 into 1 lakhs into 8 years. Why? Because 7.8, that is 7 years 8 months, will be rounded up to be 8 years. Clear? In case of seasonal employees, this will become 7/26 for employees who have worked for few seasons and 15/26 for the employees who have worked throughout the season. I discussed that at the time of death or disablement of a person, the minimum eligibility time period doesn't work. That is, if an employee has worked even for 1 year and he expires, then he'll be getting gratuity for that period of time for which he has worked in the organization. And in case of permanent disablement also, the employee will get his gratuity. But let's first understand that in case of an employee who after disablement has joined the organization again on reduced wages, then his for gratuity calculation, the wages for the period preceding his disablement shall be taken to be the wages received by him during that period. So with this, I come to the end of this topic. Do like and subscribe my channel, Simplified Basic Concepts. Thank you.